Welcome to Keys to Your Legacy. Did you know that 40% of marriages today involve blended families? That means that many families today look kind of like the Brady Bunch. Blended families when one or both spouses have children from a previous marriage or relationship. Estate planning, which is essentially making a plan for what happens to your money, your home, your belongings when you pass away, can be really tricky for blended families, and here's why. If a husband or wife dies, their money or property might go only to their kids, leaving the other spouse with nothing. Or everything might go to the husband or the wife who's still alive, leaving the kids from the first marriage with nothing. And if there's no plan, the government decides who gets what. That decision might not be what you wanted. So today, let's talk about how estate planning can help protect your wishes. Make sure everyone in your family is taken care of. So let's take a look at a famous blended family, the Brady Bunch. Mike was a dad with 3 sons, Greg, Peter, and Bobby. Carol was a mom with 3 daughters, Marcia, Jan, and Cindy. They had a weird live-in situation with a caregiver, Alice. Not really sure what she did, except that she cooked. When they got married, that's Carol and Mike, not Alice. When they got married, they became one big family. Now imagine years have passed. Mike and Carol are now in their 60s and their kids have all grown up. Even though they love each other, they have decided to keep most of their finances separate. Mike and Carol do not have a joint bank account. They don't share investments, but they do own their famous Brady Bunch house together, and it's paid off. That sounds simple, right? Here's a big question. What happens if one of them dies? The problem with no estate plan is that there's no plan. California decides. Let's say Mike passes away first. He wants his money and belongings to go to his 3 sons. Carol wants her money and belongings to go to her 3 daughters. But without an estate plan, things get messy. If Mike didn't make a will or a trust, the law decides who gets his things. Carol could inherit everything, leaving Mike's sons with nothing. Or Mike's sons might have to fight in court to get what their father wanted to leave them. That's why it's so important for blended families to make a clear estate plan. So let's start with the basis of a plan, a living trust. One of the best ways to protect everyone in a blended family is for people to create their own revocable living trust. Sometimes it's called a revocable trust. Sometimes it's called a living trust. It is a trust that is a legal document, and it helps you decide who gets what when you pass away. It puts a trusted person in charge of your money if something happens to you. And because it's living, or also called revocable, it allows you to make changes anytime while you're still alive. The best part, a trust avoids the probate court process. Now, what's probate? Probate is a long, expensive court process where a judge decides who gets your belongings if you don't have a plan. For families like the Bradys, a revocable living trust makes sure everything goes how it should. Now, property in a marriage works differently than property owned by an individual person. In California, there are 2 types of property in a marriage. First is separate property. This belongs to only one person, only one spouse, and it includes anything they owned before marriage, any gifts or inheritance they received, and any money made from their separate property, like rental income paid from a rental property that's owned by one spouse alone. But then everything else is community that belongs to both people. And it includes any money that either person earns during their marriage or any property or things that they bought together. But there's something that gets tricky. If you mix separate and community property together, the law assumes that you wanted it to be owned by both of you. This means even if Mike bought something before marriage, if he and Carol own it together, it's considered community. How does this affect inheritance? Let's say Mike and Carol don't have a trust. Well, what happens if Mike passes away first? The community property, things they earned or bought together, goes to Carol 100%. The separate property, things Mike owned before marriage, gets split between Carol and his 3 sons. You might say, what if their house is in joint tenancy? Well, joint tenancy means that both people own it together and there's a right of survivorship. The survivor gets the property. That means that when Mike dies, the whole house goes to Carol. Well, when Carol passes away later, either if the house is community property or if the house is in joint tenancy, Carol owns the house. And when she dies, her 3 daughters get everything. There's no more community property after Mike dies. Carol is no longer married. She owns her house individually. You remember that if Carol is not married, her children are her heirs. Mike's children are not. So without a plan, the house goes entirely to Carol's children. Now, Mike and Carol didn't do this on purpose. It's just how the law works because they didn't have a plan. So how can a blended family like the Bradys plan their estate? Well, let's discuss 3 options. Option 1, separate trusts. Mike can create his own trust for his sons. Carol can create her own trust for her daughters. Everything stays separate. That means Mike has his own called separate property trust. It's a living trust that is only created by Mike and holds Mike's things. Carol does the same thing. Carol's trust holds Carol's things. So it's Carol's separate property living trust. Option 2, they could create one joint trust together. So Carol and Mike can create a joint living trust. And when one spouse passes away, oftentimes the other spouse can make changes to that trust. They might not want that. They might want that. There's a third option, a combination of a separate and a joint trust. Mike and Carol can each create their own separate property trusts. They can also have a joint trust for the things that they share, like their house. This third option protects both of the spouses and protects the kids. For blended families, the third option is often the best choice. So estate planning isn't just about money. It's about family. And that can get really emotional. Sometimes kids don't trust their step-parent to share fairly. Carol's daughters might not trust Mike. Mike's sons might not trust Carol. Sometimes arguments happen over who gets what. These types of conversations are really uncomfortable. But you should have them now, before it's too late. When it's too late, that conversation can no longer happen. If there's a lack of trust, that conversation becomes incredibly difficult. The children now have to step in the role of their parents and see what the parents might have wanted. When there's money on the line, motivations can get mixed up. That's why making a clear legal plan is so important. So estate planning for blended families is different than planning for traditional families. The key is to have a plan, because if you don't, your family might end up in court, have fights over money and belongings, see their inheritance go to the wrong person. A trust helps make sure that your family's protected and your wishes are followed. Probably the most important thing is to make sure that your family can be a family. Blended families are tough. There's a lot of barriers between blended families. You don't want a bad plan or no plan to come in the way of family members continuing to be family when you're gone. Thank you for watching. I hope this video helped explain estate planning for blended families. If you found it useful, be sure to like and subscribe and share the video with someone who you think it might be helpful. We really want to help as many people as we can.